Let me fill you in on something that just happened behind the marble walls of the Supreme Court that should terrify anyone who cares about American democracy. Three justices, three, walked out of a closed-door conference last Thursday afternoon after what sources inside the building are calling the most explosive confrontation in modern court history. According to Politico's October 23rd report, Chief Justice John Roberts was overheard shouting, yes, shouting, at Justice Samuel Alito about a pending case that could redefine presidential immunity. Court staff who've worked there for decades told MSNBC they've never witnessed anything like this. The constitutional crisis we've been worried about? It's not coming, it's already here. Here's the scoop. The Supreme Court is supposed to be the steady hand in American government, the institution that rises above political theater, but right now, the justices can't even stay in the same room together. This isn't about legal philosophy or interpretive methods. This is about fundamental disagreements over whether a sitting president can claim absolute immunity from criminal prosecution for actions taken while in office. The case that triggered this eruption, Trump versus United States, was accepted for oral arguments on December 4th after three separate appeals courts ruled differently on the same constitutional question. The legal contradictions created a procedural nightmare that forced the Supreme Court's hand. The implications stretch far beyond one case or one presidency. Constitutional law expert Lawrence Tribe, professor emeritus at Harvard Law School and author of 16 books on constitutional interpretation, stated in his CBS interview on October 19th that we're watching the Supreme Court fracture along lines that have nothing to do with law and everything to do with maintaining power structures that were never supposed to exist in a democratic republic. Those aren't the words of a partisan activist. That's one of America's most respected constitutional scholars, warning us that the court has become unmoored from its institutional purpose. Let's be real for a second. The American system of justice depends on one fundamental principle that every seventh grader learns. No one is above the law. For 250 years, that principle held steady through wars, depressions, and countless political crises. Presidents left office and faced normal legal accountability like everyone else. Richard Nixon resigned rather than face impeachment, and accepted a pardon because he understood that presidential immunity had clear boundaries. Bill Clinton was deposed under oath as a sitting president in a civil case. The legal framework was never perfect, but it was consistent. Presidents enjoy certain protections while in office, but those protections have defined limits and eventually end. Then came the trigger event that changed everything. On October 3rd, the D.C. Circuit Court ruled in a separate but related case that presidential immunity does not extend to actions that violate federal criminal statutes, even if those actions fall under broad categories of presidential duties. The ruling was narrow, carefully crafted, and seemed relatively straightforward. 3 days later, Justice Alito issued an extraordinary public statement. Not a dissent, not a concurrence, but a unilateral declaration, arguing that the Circuit Court had fundamentally misunderstood the constitutional architecture of executive power. According to CNN's legal analyst Ailey Honig, a former federal prosecutor with 12 years of experience in the Southern District of New York, this kind of public pronouncement from a sitting justice before a case reaches oral arguments is virtually unprecedented and raises serious questions about judicial impartiality. The pattern here is disturbingly familiar to anyone who's watched power consolidate over the past decade. Jeff Sessions served as Attorney General from February 2017 until November 2018. When he recused himself from the Russia investigation because of his documented contacts with Russian officials during the 2018 campaign, he followed standard Justice Department protocol for avoiding conflicts of interest. The response? Public humiliation, constant attacks via Twitter, and eventually forced resignation. Sessions did exactly what legal ethics required, and his career was destroyed for it. William Barr took over as Attorney General in February 2019. Legal experts across the political spectrum, including former Republican Justice Department officials like Stuart Gerson and Donald Ayer, criticized Barr's March 2019 summary of the Mueller report as a misrepresentation of the special counsel's findings. The actual Mueller report, released weeks later with redactions, painted a far more complex picture of potential obstruction. But Barr's 4-page summary had already shaped public perception. For that service, Barr maintained his position until December 2020. The lesson was clear. Protect presidential power without question. Keep your job. Follow traditional legal boundaries. Face destruction. Mike Pence served as vice president for 4 years with apparent loyalty. On January 6, 2021, when presented with a constitutional duty to certify electoral votes, Pence consulted with legal experts including J. Michael Luttig, a conservative former federal judge appointed by George H.W. Bush. Luttig's legal analysis, documented in his testimony before the January 6th committee on June 16, 2022, concluded unambiguously that the vice president has no constitutional authority to reject electoral votes. Pence followed that constitutional guidance. The result? Death threats against him and his family, a gallows erected outside the Capitol with calls for his hanging, and permanent exile from political relevance within his own party. His reward for constitutional fidelity was becoming a pariah. Kevin McCarthy became Speaker of the House in January 2023 after 15 ballots, the longest Speaker election since before the Civil War. 9 months later, he was removed from the speakership in October 2023, the first time in American history that's ever happened. His political sin? Working with Democrats to avoid a government shutdown, which is literally part of the Speaker's constitutional responsibility to keep the government functioning. McCarthy's career ended because he briefly prioritized institutional stability over partisan warfare. Now here's the kicker. Look at the impossible catch-22 facing any justice, any official, anyone in a position of legal authority. Option 1. Follow the Constitution as written, interpret the law based on 250 years of precedent, and maintain that presidents are subject to criminal prosecution after leaving office for acts that violate federal law. If you choose this option, you face coordinated political destruction, death threats against your family, and permanent professional exile. Your name becomes a rallying cry for everything wrong with the system. Your legal reasoning gets dismissed as partisan activism, regardless of its constitutional merit. Option 2. Embrace an expansive theory of presidential immunity that contradicts centuries of American legal tradition but protects current power structures. Argue that presidents need broad immunity to function effectively, even if that immunity extends to potentially criminal acts. Rule that presidents cannot be prosecuted for official acts, regardless of whether those acts violate criminal statutes. If you choose this option, you maintain your position, avoid the mob's fury, and get praised as a defender of executive authority. Your legal philosophy gets celebrated as pragmatic and realistic. The consequence of option 1 is professional and personal annihilation. The consequence of option 2 is the fundamental restructuring of American democracy into something closer to an elected monarchy. Those are the actual choices on the table right now. There's no middle ground left, no compromise position that satisfies both constitutional law and political survival. Here's where it gets interesting. The fracturing inside the Supreme Court reflects this impossible dilemma. According to Fox News legal correspondent Shannon Bream's October 21st report, citing multiple sources familiar with internal court dynamics, at least 4 justices are deeply concerned about the political ramifications of any ruling on presidential immunity, regardless of how they rule. That's a stunning admission. These justices aren't worried about getting the constitutional law correct. They're worried about surviving the political firestorm that follows. During the closed-door conference on October 17th, 3 weeks after the D.C. Circuit ruling, Chief Justice Roberts reportedly argued for a narrow procedural ruling that would delay any substantive decision on presidential immunity until after the 2024 election. According to Politico's sources, who spoke on condition of anonymity because court deliberations are confidential, Roberts said explicitly that the court cannot withstand another Bush versus Gore moment where we're seen as deciding a presidential election. Justice Alito's response, overheard by court staff in the hallway afterward, was that sometimes the court must make unpopular decisions to preserve constitutional order. Translation: Alito believes the court should rule that presidents have broad immunity. Political consequences be damned. The legal challenge that emerged from this conference fight arrived faster than anyone expected. On October 25th, Jack Smith, the special counsel investigating federal charges related to January 6th, and classified documents, filed an emergency motion with the Supreme Court. The motion, which you can read in its entirety on the Justice Department website, asked the court to resolve the immunity question before the scheduled trial date in March 2024. Smith's argument is straightforward. The appeals process has created enough delay that justice itself is threatened. His brief cites United States versus Nixon, the 1974 case where the Supreme Court ruled unanimously that President Nixon had to comply with a subpoena for the Watergate tapes. In that case, the court moved with extraordinary speed, just 16 days from oral arguments to decision, because they understood the constitutional stakes. Smith's emergency motion included language that rarely appears in legal filings. He wrote that the fundamental principle that no person is above the law demands resolution of this question with urgency, commensurate with its constitutional gravity. Then came the sentence that apparently triggered Justice Alito's public response. Smith wrote, "Any theory of presidential immunity that would prevent prosecution for criminal acts strikes at the heart of democratic self-governance and is constitutionally indefensible." Constitutionally indefensible. Those two words set off alarm bells inside the court. Within 48 hours, Justice Alito issued his public statement I mentioned earlier, arguing that the special counsel had prejudged the very question before this court and shown concerning bias against executive authority. But here's what makes Alito's statement so extraordinary. He released it before the court had even voted on whether to grant Smith's emergency motion. He essentially announced his position before the full court had deliberated. According to Yale Law School professor Akil Reed Amar, who clerked for Justice Stephen Breyer and has argued before the Supreme Court multiple times, this breaks every norm of judicial deliberation. Justices signal their views through questions at oral arguments, through their written opinions, through carefully crafted public speeches, Amar told MSNBC on October 27th. They don't issue unilateral press releases attacking parties before a case has been properly briefed. The conservative legal establishment started fracturing too. On October 29th, Judge J. Michael Luttig, remember he's the conservative former federal judge who advised Pence, published an op-ed in the New York Times titled, "The Court Must Reject Presidential Immunity." Luttig's argument was devastating in its clarity. He wrote, "For 2.5 centuries, American presidents have understood that they serve at the pleasure of the people and remain subject to the law after they leave office. Any deviation from this principle does not strengthen executive power. It corrupts it absolutely by removing the one check that keeps presidents tethered to their constitutional obligations." Luttig's piece included 3 historical examples that destroy the immunity argument. First, when President Grant's personal secretary was indicted for his role in the whiskey ring scandal in 1875, Grant submitted to a deposition while still in office. He didn't claim immunity. He answered questions under oath because that's what the rule of law required. Second, when President Theodore Roosevelt was sued in a libel case in 1915, after his presidency ended, he didn't argue that his actions as president gave him perpetual immunity. He defended himself in court and won on the merits. Third, when President Truman seized steel mills during the Korean War in 1952, the Supreme Court ruled against him in Youngstown. Sheet and tube Cumber C. Sawyer. Truman complied immediately. He didn't argue that presidential immunity protected him from judicial review. He accepted the court's ruling because that's how constitutional democracies function. Now here's what that fracturing means for the court itself. Remember, these justices have lifetime appointments specifically to insulate them from political pressure. The idea is that federal judges never have to worry about re-election or partisan backlash, so they can rule based purely on law and constitution. But that protection only works if there's broad public faith in the institution's legitimacy. Once that legitimacy erodes, once people believe the court is just another political actor making decisions based on partisan preference, the entire constitutional structure becomes unstable. We're watching that legitimacy collapse in real time. A YouGov poll conducted October 23, 2024, with 2,500 registered voters and a margin of error of plus or minus 2. 5 percentage points, found that only 38% of Americans trust the Supreme Court to make decisions based on the law rather than politics. That's the lowest number since polling began tracking this question in 1972. More striking, among voters under 35, that number drops to 22%. An entire generation has lost faith in the court as a legitimate legal institution. Let's break this down into three concrete implications. First, the political fallout will be immediate and severe regardless of how the court rules. If they embrace broad presidential immunity, Democrats will spend the next decade arguing that the court has created an American monarchy. Progressive groups are already drafting constitutional amendments to limit presidential power and reform the Supreme Court structure. I'm not speculating here. The draft language is publicly available on multiple advocacy websites. If the court rejects presidential immunity and allows prosecutions to proceed, Republican leaders have made clear they'll treat it as a political attack. Senator Mike Lee of Utah said in a Fox News interview on October 24th that any ruling that allows politically motivated prosecutors to target former presidents will result in a constitutional crisis that may require congressional intervention. That's not a legal argument, that's a threat. Second, institutional damage to the judiciary will last generations. Federal courts depend on voluntary compliance. They have no army, no police force, no ability to enforce their rulings except through public faith in legal authority. Not since the Watergate era have we seen this level of public distrust in the Supreme Court. But here's what's different from Watergate. Back then, the court moved quickly, ruled unanimously, and restored public faith through decisive action. In United States versus Nixon, all 8 participating justices agreed that Nixon had to turn over the tapes. That unanimity sent a powerful signal that law transcended politics. Today's court can't find unanimity on basic procedural questions, let alone substantive constitutional issues. When Justice Alito publicly attacks the special counsel before oral arguments even happen, he's telling the country that this court has chosen sides before hearing the case. Third, electoral implications stretch far beyond 2024. Whoever wins the presidency will inherit a Supreme Court that has either blessed expansive presidential immunity or infuriated half the country by rejecting it. If the court rules for immunity, future presidents will have unprecedented power to act without fear of legal consequences. If they rule against immunity, we'll see constitutional warfare that makes the current fights look tame by comparison. Either way, the court itself becomes a central campaign issue. Candidates will run on court reform, court expansion, jurisdiction stripping, mandatory retirement ages, term limits, all the ideas that have been floating around progressive circles for years. Those ideas will become mainstream Democratic positions overnight. Think about what that means for the next 20 years of American politics. Supreme Court nominations have always been contentious, but they operated within certain boundaries. Even controversial nominees eventually got confirmed with some bipartisan support. Those days are over. Every Supreme Court vacancy will become an existential political battle because the stakes now include whether presidents can be prosecuted for crimes. That's not a legal question anymore. It's a question about what kind of country we want to be. The next few weeks are crucial because the Supreme Court has to respond to Jack Smith's emergency motion. They can grant it and accelerate the timeline, which means oral arguments before the end of 2024 and a decision by early 2025. They can deny it and let the normal appeals process continue, which pushes any decision past the election. Or they can do what they did in Bush versus Gore, issue a narrow ruling that decides nothing while simultaneously deciding everything. Each option carries massive consequences. Meanwhile, the internal warfare at the court continues. Sources tell Politico that Justice Clarence Thomas hasn't spoken directly to Justice Sonia Sotomayor in months. Their communications go through law clerks. Justice Amy Coney Barrett reportedly tried to mediate between Roberts and Alito and got shouted down by both of them. These aren't just interpersonal conflicts. These are ideological battles over the fundamental structure of American democracy, playing out among 9 individuals who were supposed to be above such fights. Here's what keeps me up at night about all this. The Supreme Court is having this internal meltdown while simultaneously being asked to resolve the single most important constitutional question of our generation. Can presidents commit crimes and claim immunity? The court that's supposed to answer that question can't even maintain basic collegiality. The justices who should be modeling legal reasoning and institutional stability are instead engaging in public warfare through leaked comments and unauthorized statements. And the truly terrifying part? There's no obvious way out. The legal question has to be answered one way or another. Presidential immunity either exists in this expansive form or it doesn't. There's no middle ground that satisfies both legal tradition and political reality. Someone is going to be furious with the court's decision, and that fury will have legitimate constitutional backing. If they rule for immunity, they're ignoring 250 years of American legal tradition. If they rule against immunity, they're opening the door to endless politically motivated prosecutions of former presidents. The catch-22 I described earlier, choose constitutional law and face destruction, or protect power and corrupt the system, now applies to the Supreme Court itself. They can rule based on legal precedent and watch their institutional legitimacy collapse, or they can rule to maintain political peace and abandon their constitutional duty. Neither option preserves what the Supreme Court is supposed to be: an independent judiciary that interprets law without fear or favor. We're watching the constitutional crisis unfold in slow motion. Every day brings new leaks from inside the court, new public statements that violate judicial ethics, new evidence that the institution designed to be above politics has become hopelessly entangled in partisan warfare. The oral arguments haven't even happened yet, and already the damage is severe. What happens when they actually have to rule? The stakes have never been higher, and the institution responsible for navigating these stakes has never been weaker. Something has to give. The question is whether it's the court's legitimacy, the rule of law, or American democracy itself. Right now, all three are hanging by threads far more fragile than anyone in power wants to admit. The next few weeks will tell us which thread breaks first.